You were served with a protective order and suddenly everything changed. You can't go home, you can't see your kids, and if the other person wants to drop it, you're still stuck with court dates, restrictions, and a public record. I'm John Cannon. I'm a criminal defense attorney here in Oklahoma, and I help people remove protective orders and get their rights back fast. This video walks you through exactly how the process works, what the court actually looks for, and how to give yourself the best shot at getting the order dismissed, so you can move forward without a protective order hanging over your head. In Oklahoma, a domestic violence protective order is a court order. It's not a warning, it's not a suggestion. It is a judge's directive. Depending on what the judge orders, it can restrict contact, require someone to stay away, remove someone from a home, control how property is handled, and set rules around school, workplace, and family contact. And here's the part that caused the most trouble. The order is enforceable exactly as written until a judge changes it. Even if the petitioner texts you, even if they say it's fine, even if you two are trying to work things out, none of that changes the legal reality. If the order says no contact, it means the judge has ordered no contact. If it says stay away, it means stay away. The only safe way to change those rules is through the court. Two sides typically have the ability to go back to court. The petitioner is the person who asks for protection. The respondent is the person the order is against. Either side can ask the court to modify the order or dismiss it, depending on the situation and what the judge is willing to do. If the petitioner wants it dismissed, that certainly helps. But it still isn't automatic. The judge can still ask questions. The judge can still keep protection in place if the judge believes it is necessary. If the respondent wants to dismiss, that can also be done. But you should expect the court to focus heavily on safety, compliance, and what has changed since the order was originally entered. Protective orders often begin as an emergency or temporary order. Those are designed to hold things in place until a full hearing in front of the judge. A final order is longer term. Some final orders have a specific end date. Some last until a future court order changes them. Here's the practical truth. You can seek a change at many points in the life of the order, but you don't want to ask in a way that looks reckless or premature. Judges want to see stability. Judges want to see a track record of compliance. Judges want to see that the reasons for the order have changed in a real and meaningful way. If you're the respondent, the most helpful thing you can do for your future is boring consistency. No violations, no back-channel communications, no accidental run-ins, no contact through friends, no social media. Clean compliance every day for as long as the order is active. To remove a protective order in Oklahoma, you typically have to ask the court in writing. That means filing a motion in the same court where the protective order was issued. People use different labels for this, like a motion to dismiss, a motion to terminate, a motion to modify, or a motion to vacate. The label matters less than the substance. You're asking the judge to change or end an existing order. After that motion is filed, the court can set a hearing date, and the other party must receive proper notice of the hearing. That matters because the judge needs both sides to have the opportunity to show up and to be heard. Then you go to the hearing, and you and your attorney present your request in a way that the judge can act upon. And this is where most people mess it up. They show up and tell the judge how they feel. They tell the judge they're frustrated. They tell the judge the order is unfair. That usually does not move the needle. What moves the needle is facts, proof, and changed circumstances. Judges in protective order cases are trained to think in terms of safety and risk. So the first question is usually, have there been any problems since the order was entered? If there have been violations, that's a major issue. Even small violations matter to the court. A single message, a single phone call, a third party passing a note, a just checking in on you, to a judge, that can look like disregard for the court's authority and disregard for boundaries. Next, the judge is looking at what has changed. If the original situation involved conflict, instability, harassment, drug issues, anger issues, threats, or fear, the judge wants to know that things are different now. Not what you intend to do, what you have shown that you have already done. This is where documentation becomes your friend. Proof of counseling, proof of completion of programs, proof of stable residency, proof of employment, proof of treatment, if that was a factor. Proof that you have followed the order and stayed out of new trouble. Then the judge considers the petitioner's position. If the petitioner appears and says they still feel afraid, still feel pressured, still feel harassed or at risk, many judges are very cautious. Even if you disagree, even if you believe fear is exaggerated, the judge's job is prevention, not just reaction. If the petitioner supports dismissal, that can help, but is not a magic wand. Judges can still keep an order in place if they believe the facts support continued protection. Finally, the judge watches your demeanor. Are you calm, respectful, direct? Do you take responsibility when appropriate? Do you not talk when it's the other party's turn? Are you using the courtroom to keep the conflict going? Those impressions matter more than most people realize. Here's a common pattern that we see. Someone has a final protective order entered after a breakup. The respondent stays away and follows the order. No violations, no side contact, no drama. Over time, the conflict cools down. The parties move on. The respondent completes counseling and builds a stable routine. The petitioner is no longer reporting ongoing issues. When that respondent turns to court, they are not asking the judge to just believe them. They are showing the judge a record of compliance and a real change in circumstances. That is the kind of request a judge can say yes to. Now flip it around. If the respondent has violated the order, argued with police, continued contact, shown up by accident, or tried to pressure the petitioner to dismiss, the court often sees that as proof the order is still necessary. Some protective orders are more complicated than others. If children are covered by the order, the court is usually more cautious. Judges don't like uncertainty around exchanges, school events, and contact rules. If co-parenting is part of the picture, modification may be more realistic than full dismissal at first, depending on the facts. In Oklahoma, most of the time will be consolidated with the family case, so it's important to get ahead of it. If there's a criminal case pending, that overlaps with the protective order allegations. The protective order case can become more sensitive. In many situations, courts are reluctant to loosen protections or modify when there's a related criminal case pending. If there are multiple prior orders, repeated filings, or history of conflict, courts often require stronger showing of change and stability before they'll dismiss an order. And again, violations matter. If you want the court to trust you, you have to show the court you can follow its orders. You are generally allowed to file a protective order on your own, but protective orders can affect housing, employment, family relationships, and sometimes other legal rights. If your order intersects with custody, divorce, DHS, probation, or criminal charges, the strategic risk can go up fast. A lawyer can help you do 3 things that matter. 1, file correctly. 2, present evidence in the right way. And 3, avoid mistakes that create new problems for you. And one more point, a lawyer can help you communicate the right way, because the worst pattern I see is someone trying to work it out informally or accidentally committing a violation in the process. If the judge dismisses or terminates the protective order, the restrictions in that order end. But that does not automatically end other court rules that may exist. Bond conditions, probation conditions, custody orders, or criminal no contact orders can still apply even if the protective order is gone. So the smart move is to get clarity on what rules still exist after dismissal and to keep a copy of the court-signed order so you can prove what happened if questions ever come up later. Here's a quick recap. In Oklahoma, a domestic violence protective order stays in effect until a judge changes it. Either side can ask the court to modify or dismiss the order, but the judge decides based on safety, compliance, and changed circumstances what they're going to do. The fastest way to lose credibility is to violate the order, even just once, even with the other person's permission. The strongest requests are built on clean compliance over time, real proof of change, and a calm, respectful presentation in court. And if there's one thing all of this should make clear, it's how quickly a situation can spiral based on just a few words or one small mistake. Because a lot of people don't realize the moment law enforcement gets involved, every question has a purpose. It's not casual conversation, it's building a case. And that's exactly why you need to know how to handle these moments before they even happen. In the next video, I'm going to show you exactly what to say when an officer asks you one of the most common questions out there. Where are you coming from? And how your answer can either protect you or put you in a bad spot. I'll see you over there.